know, we've had the safe harbor agreement between the EU and the US for quite a while on privacy, so that companies trading both in Europe and the United States could comply with the different requirements. And I think that what these things show is that conceptually, at least, we're getting closer to convergence, even if they're not going to be entirely harmonized or interoperable. I think we've covered that already. So let's move on to cybercrime and cybersecurity. So just a couple of headline features. We all know cybercrime is a problem and it's bad. And depending on which study you go to, you get different results and you get different sort of panic numbers. But it's pretty big. So a recent study by Norton, the people who provide the software for protecting your computer, say that on one end of the scale, they estimate the economic harm to be $114 billion. Then they say if you add in the time that it takes to remediate and to prevent and the other sort of hidden costs, that number gets bumped up pretty significantly. So it's a pretty big number. There was another study that came out by a congressional office in October, and it refused to sort of put a number on the problem, but it did say, look, cybercrime is a national security interest. And so again, we see this sort of, you know, economic thing that's happening in one sphere being equated to a national security issue. And so these two domains are kind of intersecting again. And then another study, and this one was done by HP, said that on average, US enterprises that were surveyed suffered $5 million of direct and indirect damages as a result of cybercrime. So all I'm not an academic, but if an academic were to look at these things, they would start to peel away the different methodologies and see that the HP study was a survey of 50 US enterprises. I don't know how represented that is. The Norton study was an online survey of individuals and then aggregated. And so I think there are a lot of potential issues with the data, but at least they're representative of a looming problem. But in the area of cybersecurity, we see that there are, again, a number of different actors involved. And it's depending on where you are in the world, it can be a primarily private sector driven activity. The international standards bodies are looking at things. We have the certs, which I've mentioned before. But some of the issues that we're concerned about going forward are how to, okay, so we have this problem, and then what is the legal response to it? What can be done statutorily or otherwise to address these looming problems? When you add on top of that the international aspect, it gets very, very complicated because all of a sudden you're dealing with a lot of different jurisdictions. So as I mentioned before, one of the principal instruments that's out there to fight cybercrime is the Council of Europe Convention, sometimes called the Budapest Convention. And the URL is there. The interesting thing about the convention is, even though it is the Council of Europe Convention, it is open to signature by non-European states. And how many of you knew that the United States is a signatory to this convention? Good. Well, now you all do. It was one of the few international instruments that was acceded to under the Bush administration, interestingly enough. And it covers 5 or 6 sort of major substantive issues. Interference with systems, interference with data, interference with computers, but it also importantly deals with cross-border issues, how law enforcement agencies can interact with one another in the space. It's not the only instrument out there. There is also the Commonwealth Organization, which has promulgated a model law. The model law that it was promulgated is based upon the Council of Europe Convention. It's not identical, but it was based on it. And it is available out there. So some 100 or so countries have adopted legislation that essentially follow the Council of Europe Convention, which is pretty good at some level. But when you consider that there are 198, I guess 199 with South Sudan being a country now, countries out there, that means roughly half have legislation that deals with cybercrime. That also means that roughly half don't. And that leads to what I consider one of the major problems in cybercrime globally is this creation of safe havens for cyber criminals. So it's great that we have cybercrime legislation. It's great that the other 99 countries do, but what about the 99 that don't? And you know, if you're a cyber criminal, you're probably going to locate there. So that's a major problem in the global fight against cybercrime. So it's great that we've got cybercrime legislation, but how effective is it outside our borders? I don't know. There are a couple of other problems in the global area of cybercrime. One is that even with all those countries who have acceded to the convention, even with all those countries who have legislation that is consistent with the convention, the application is variable. And so again, if two countries, for example, have a cybercrime incident that affects both of them, but they don't have the proper information sharing or the proper coordination mechanisms between their law enforcement agencies, then it kind of doesn't matter. I mean, they need those very practical links to make things happen. So that's one problem. The other, I mean, there are many problems. One of them also is what I call a dissonance of policy approach. And that's where countries, even in the same region, approach the issue of cybercrime differently. They have different policy objectives. Those policy objectives are then reflected differently in national law, and so you get, again, these tensions. Some recent actions by the US government, again, the White House had issued a cybersecurity plan in 2011. Department of Defense is constantly working in this area, Department of Homeland Security as well. And so even within our own government, you've got these kind of pockets of activity that don't necessarily talk to each other. And here's what I'd like to focus on a little bit. It's an October guidance statement from the Securities and Exchange Commission. And in it, it's not mandatory, but in it, they would like to suggest that companies disclose in their securities filings, their 10Ks and 10Qs, if there are cybersecurity issues that investors should be aware of. And in the guidance note, which is, I don't know, 4 or 5 or 7 pages or something, they go through what they consider to be, you know, standards of materiality and stuff like that. As far as I'm aware, there's been one company that has specifically done this in a filing, that was Con Ed from New York. And it was a fairly pablum statement saying, well, you know, a natural disaster could shut our system down and that would have deleterious effects on the economy. Okay. They've acknowledged it. They see it as a material risk. But consider if you're one of these companies and you think you are about to be, or if you think you have a vulnerability in your system that might be material, or if you've had a significant cyber attack, you probably don't want to disclose it. And the reasons you don't want to disclose it are probably the very same reasons why the SEC wants you to disclose it. But the SEC in its paper does, in its guidance note, does recognize that there might be things that you don't want to disclose because you'd be telegraphing your vulnerabilities to the bad guys. And so they recognize that balance. So you know, this is I think we'll be seeing more and more of it. I wouldn't doubt if what we get to is kind of a boilerplate statement by companies. Yes, there are risks out there. Yes, we're taking appropriate measures to deal with them. But I don't think that the incentives are in place necessarily for the kind of disclosures that they're really after. So how do we measure this stuff? I mean, from the standpoint of the World Bank, we are a financial institution, and we want to know what the scope of the problem is. And the last point here, I think, is one where we're going to have to do a bit more work. And that is to look at the insurance carriers and the reinsurance carriers to see what sort of policies they're underwriting for entities who are listed, and see the scope of that market as a kind of a way to reverse engineer what the real damages are. Okay, very quickly on .war. You know, the problem to me is we had from a U.S. perspective, we had starting with George Kennan in the Department of State in the 40s, this idea of containment. And there was a military strategy that went along with that. And that was, you know, we're not going to confront you directly. We're going to do stuff to limit the damage and keep you in a box. And it's difficult to apply that notion, I think, in the cyber war area. Very difficult to know where the people are, very difficult to know when it's going to occur. Yet we have a policy of deterrence in place, and I don't know that those traditional ways of looking at protecting the country are going to be applicable in that area, but also where, again, this is where we have to balance things. If these deterrence measures are put in place, how do they affect the human right of receiving and imparting information? How do they affect privacy rights? And so we see that what used to be a national defense issue is now also affecting potentially our rights as individuals. I think we've talked about most of the issues on the jurisdictional side, and we can address some of them in questions. But I think the jurisdictional issues are particularly difficult, and I don't have any answers to them. I can raise some of the questions, but it's really difficult when you're dealing with non-state actors who aren't necessarily in a particular place at a particular time, or in many places at many times, and when you have these gaps in the international legal architecture for enforcement and coordination. So these jurisdictional issues are not going to be solved, I don't think, without fixing some of those underlying meta issues. So just a couple of words then on the legal paradigm that we're proposing from all of this. So we've got the statement of the rule. Let's take the human rights thing as an example. You have the right to receive and impart information. But then there are certain exceptions, like public order. And even where you have those exceptions that can derogate from that rule, they have to be done in a certain way. They have to be transparent, predictable, proportional, et cetera. Here we have a couple more examples, and I'll wrap up with this and then open it up to questions. One of the major things that we've seen, and it's adhered in the multi-stakeholder approach to internet governance, is the recognition that in this space, non-state actors are as important as nation states. And so in the international area, which is the realm that I work in day to day, even my institution is based upon kind of 19th century notions of the Westphalian state and how those states interact with each other. For example, when we make a loan, we're a sovereign, and when we make a loan to a country, it's sovereign to sovereign agreement, that's a treaty. So even